Reese Smith, Franklin.
Jerry Hayes, Paris.
Keith Whittington, Johnson City.
Randy Chase, Nashville.
Mark Brudd, Knoxville.
Ronnie Tickle, Memphis.
All right. I need a motion to adopt the agenda.
Motion.
Second.
Got a motion and a second. All those in favor?
Aye.
Any opposed? Okay. Got hardships. I need a motion, I guess, to take care of the hardships approved by Carolyn.
Motion.
Second.
Motion and a second. All those in favor?
Aye.
Aye.
Any opposed? All right. Since this is the first meeting of the year, we need to adopt Robert's Rules of Order. Can I get a motion?
So moved.
Second.
Got a motion and a second. All in favor?
Aye.
Any opposed? Again, being the first meeting of the year, we've got a conflict of interest form that everybody needs to execute. I think everyone has that. Just make sure you get that done and get it back to Carolyn. The board meeting transcript from November the 21st, I'm sure everyone reviewed those. I need a motion to approve the November 21st meeting minutes.
Motion.
Second.
We have a motion and a second. All those in favor?
Aye.
Aye.
Any opposed? All right. Waived files. We need a motion to approve all the waived files.
Motion.
Second.
Motion and a second. All in favor?
Aye.
Aye.
Any opposed? Interviews. Do we have some interviews that we need to go over? Reese, did you have any?
No.
Anybody?
Okay, I've got three that I need to bring up before the board. The first one is number 74457, Creative Home Builds. Their application was all in order with the exception of ground up experience as between the owner and the QA. They were very limited in what they gave us, so I have denied it. Hopefully that they will take the denial, and Kathy actually requested they send in more detailed experience, and they failed to do that, so I've denied it based on that until we get more experience. The second one is number 74342, Max Construction. They have no ground-up experience whatsoever, and I'm recommending denial on that application as well. The third is number 74354. Here again, they have absolutely no ground-up experience, no building experience. It's all electrical or local home improvement. I think he worked in the store selling carpet or something like that. So I'm recommending denial on that one as well.
Okay. Mark, did you have some files?
I do.
For interviews.
File 59592, Tidewater Construction. They were applying for an increase in their limit, and I got clarified that the projects they listed were the sales price on their homes rather than the permit price, so we thought they may be over on their license limit, but have discovered that they weren't, so I would move for them to be approved for an increase without a fine. And then Cornerstone Construction, I don't have their file with me, so I don't know the number, but they were licensed for roofing construction and have taken the exam for BC A and small b. We were questioning their experience, and they satisfied us that they have experience. And we were questioning the experience they listed, since they were only a roofing contractor, and they listed this experience as potentially working out of their classification. And we, after talking with them, they actually didn't do the work. They were just referring other contractors to the owners to perform the work. So we were okay with them. I would recommend we issue the BCA and small b without any fines.
Okay. At all?
I believe so. Well, there is a third one that I'm waiting some information. He's supposed to text me or call me. So, Cabins and Homes by Donnie Allen, license number 46443. He's wanting a monetary increase. I'm just putting that on hold until he calls me.
Okay. Ronnie?
I have one, 74455, Big Sign LLC. He's asking for a CE-E license. I've got a hold on it until March. He's got a complaint against him. We've got one of our inspectors are inspecting his jobs right now and going to bring a list of jobs that he's done, and we're going to deal with it in March.
All right. Is that it?
Yes.
Okay, that's all the waived, or excuse me, all the interviews. Do we have a motion to approve those interviews as presented?
Move for approval.
Second.
Have a motion and a second. All those in favor?
Aye.
Any opposed? All right. Revisions. Do we have any revisions? I guess they were all done prior to this today. Do we have a motion to approve all the revisions?
So moved.
Second.
Have a motion and a second. All those in favor?
Aye.
Any opposed? Okay, I did the LLEs. I approved all of them as listed on your iPad except for number 44252. I recommended that that gentleman retake the exam because it had been so long since he had his exam or his license had expired. I approved all the others, so we have a motion to approve those as I listed.
So moved.
Second.
Motion and a second. All in favor?
Aye.
Any opposed? All right. Limited license plumbers. There was just one, and it's listed on your iPad, and I approved it. So I need a motion to approve the limited license.
Motion to approve.
Second.
Motion and a second. All in favor?
Aye.
Any opposed? All right. What about home improvement? Did we have some home improvement ones as well? Anything? Were those all done before today also?
Yes.
Yes.
Okay.
Make a motion, we approve all home improvement
All right.
application decisions.
Second.
We got a motion and a second. All those in favor?
Aye.
Any opposed? All right. Go Build update.
Randy?
Do you have something else?
Yeah, I wanted to go back to the one that I had on hold. I just got a text that took care of that, so I would like to make a motion for approval of the increase for Cabins and Homes by Donnie Allen.
Second.
All right, we have a motion and a second to approve that one. All those in favor?
Aye.
Any opposed? All right. Go Build update. Do we have anybody here from Go Build? Guess not. They're not here.
Carolyn, we're not getting any advertisement in West Tennessee off of Go Bill. I'd like to bring that up.
They're not advertising because they don't have money to.
They're out of money.
Well, I guess that's a good reason. Thank you. We didn't get any before either, but that's okay.
Ronnie, Facebook?
Oh, yeah, I have 2 or 3. Whatever y'all think.
They do a lot of
Okay.
social media.
Okay.
Do you have any other update on Gold Bill besides that? Okay. All right. What about the legal report? You guys ready? Jesse?
We are. All right, we'll start with number 17. Number 17, which is 2019076441. The new decision is to close that case. Then we go to number 30, 2019070881. The decision is to authorize the assessment of a $500 civil penalty by consent order. Number 31, 2019069761. The new decision is to authorize the assessment of a $500 civil penalty by consent order. We go to 46, 2019084541. The decision is to authorize the assessment of a $1,000 civil penalty by consent order. 55, 2018088291. The decision is to close this one with a letter of warning to the pool or the company that any more complaints could subject them to a license revocation. 59, 2016069891. The decision is to close it, but to also send a letter to the complainant that this is a civil issue, and to talk to an attorney, as well as to refer a complaint to the Real Estate Commission. 66, 2019029771. The decision is to keep the previous recommendation, or the previous decision of voluntary license revocation. Number 67, 2019048321. The decision is to place this case in litigation monitoring. Number 70, 2019073921. The decision is to authorize the assessment of a $750 civil penalty by consent order. Number 83, 2019081521. The decision is to authorize this case to settle through a consent order and voluntary license revocation. 84, 2019081051. The decision is to authorize the assessment of a $500 civil penalty by consent order. 98, 2018076211. The decision is to place this case in litigation monitoring, and after litigation has been finished, authorize settlement through a $1,000 civil penalty through consent order. And then we have the commercial cases.
Starting with number 102, 2019-073281. Recommendation there was for discussion, and the board's decision was to close. Number 108, 2019-076301. Recommendation was to close. The board's decision was to send a letter of instruction to the respondent. Next, number 112, 2019-102501. Recommendation was for discussion, and the board's decision was to close. Number 113, 2019-077201. Recommendation was for discussion, and board's decision was to send the respondent a consent order with voluntary revocation language contained within it. That concludes.
Anybody have any questions about the legal report? Any comments? Can we get a motion to approve?
Move for approval.
Second.
Got a motion and a second. All those in favor? Aye. Any opposed? All right. Okay, I guess we've got a couple of companies with similar license names. Are we going to hear from those folks today?
Yes. So we first discussed this in November. I think we left off the names of the companies, but I think it's important for this continued discussion to have both of the names. I think Carolyn may have some information for you all to take a look at, and then we'll go from there.
Are these the folks back here?
Yes, sir.
They want to be,
I was going to let Carolyn
all right.
hand out the information first.
Out of each of the files, and then a spreadsheet to compare the names.
But just briefly, you can see that the two license names, Professional Construction Solutions LLC, and then Professional Contractor Solutions Incorporated. Our discussion in November, the board decided that those names were so similar that the newer licensee needed to change that name. Nick Vescovo is here. If you want to address the board and let them know which company you're representing.
Absolutely. It's my first time appearing before the board.
Speak to the microphone, please.
That's what I needed to know. Thank you. My speak button doesn't need to turn on to go. Okay. Perfect. Gentlemen of the board, I appreciate the chance to appear before you on this issue. My name is Nick Vescovo. I'm an attorney with Lewis Thomason out of the Memphis, Tennessee office, though we have offices up in Nashville and Knoxville too. I represent Professional Contractor Solutions, Inc. in regard to its intellectual property matters and its legal matters. My client takes this matter very seriously, which is why I'm here today. We received the notification from this board in December in regard to the requested name change. Respectfully, we disagree with the letter and wanted to present some points as to why. I do trademark law. That's what I do. I'm an intellectual property lawyer. I litigate trademark cases all over the country, trade name disputes. When it comes to trade names, the analysis, the questions, they're the same as they are with trademarks. Our state courts have said that. Our federal courts have said that. What we look at is the name generic, descriptive, suggestive, fanciful, or arbitrary. Those ones on the far end, fanciful and arbitrary, are our good names, our good marks, our Googles, our unique brands that don't describe the services, that aren't generic. The ones on the left end are generic or descriptive names, like Professional Contractor Solutions, Professional Construction Solutions, or a host of others that we list in the attached packet handed out, starting around page 8 and going to page 9, 10 through 11. Why does this matter for the board? Well, you don't have protection over generic names. Trademark rights don't protect those. Trade name rights don't protect those. When it comes time to searching the name through the Tennessee Secretary of State's office, we're just looking, is it the same name? If it's not the same name, we have the differences we needed. But the reason we don't offer those protections is because you don't want someone to be able to name their company, let's say it's a bar and restaurant, and to call it restaurant, and then when the next person comes along and calls it restaurant, you tell them, no, you can't say the word restaurant. I own the rights to that. Our state government, our federal government, We've developed a set of laws to prevent that from happening. The same goes with descriptive names, and that's what we have here. Probably, possibly generic, definitely gets to the descriptive level, doesn't get past that. Professional construction solutions, professional contractor solutions. If you look through the materials and you go to page 9, we also have a professional, if I can find it, concrete solutions. Second. Sorry, page 14, professional concrete solutions. We have a professional project management solutions, a host of others that have those two words in them. All of those are going to be descriptive names. They're describing the services you offer. For them to then have some type of rights or protections that should be enforced, they'd have to demonstrate what's called secondary meaning, which would mean that the general public associates those three words with the name of the company. We've seen no evidence of secondary meaning here today. In fact, all we have so far is one email, and that one email references one instance of purported confusion. And I'd like to briefly tell you about that instance of purported confusion, because what you're going to find out is it wasn't the type of confusion the courts want to see or this board should want to see in these situations. My client's, one of his employees was driving his own car and backed into a woman at a grocery store, exchanged information with the woman, told her everything. He was also wearing a PCS hat. That woman then attempted to contact him, and they called the police, did everything they were supposed to do. Nothing nefarious here at all. That woman lost the contact information. She did a Google search, and she found the Professional Construction Solutions LLC website. She contacted him, and it's our understanding that he explained that it wasn't him, his employee, that had the accident. At that time, our website was not up. It was up shortly after that. We got in touch with the woman. Everything got resolved. Everything's copacetic on that end. We then later get this complaint from Professional Construction Solutions LLC. When my client did the search for the name, Professional Contractor Solutions was not registered, and he was able to register it. Professional Construction Solutions was not using a DBA. There was no PCS DBA at that time. There was no trademark registration at that time. All of that happened after the fact. And that's also important because there's been reference in the email that was submitted to this board that I have the DBA for PCS. Well, the DBA was obtained afterwards. There would have been no way for my client to have searched for those PCS under this gentleman's name and find that it was already registered. Now, I will mention one thing. PCS is being used as a trademark. This board's job is not to govern trademarks. There's a trademark agency for the state of Tennessee. That's their job. They govern the trademark rights. This board is just to see, is the name the same or similar? And that similar part, we want to be careful on that. We don't want to set a precedent because we've seen all these names we have in here that use these type of similar words: professional solutions, concrete, construction, contractors. I think we have professional pool solutions, professional project management solutions. That's a slippery slope we start going down if we're saying every one of those names is similar. We also want to have a situation where there's an evidentiary burden in regards to these things. A trademark case, when you want to do an argument like this or a trade name case, it's not the type of thing you just stand up and you say, it's the same name, I win, you lose, judge. You usually have consumer confusion surveys, expert reports, you got to show secondary meaning, you have to present advertising revenue, registration of the marks, all of that. None of that has been presented to this board right now. You've got one single email. And if you turn to page 2 of the materials, you'll see the timeline for when the DBA was registered versus when my client formed his company. The DBA for Professional Construction Solutions was done approximately 3.5 months after my client formed its company. Moreover, when Professional Construction Solutions LLC chose its name back in 2008, there was already a Professional Construction Solutions doing business in 2007. That company proceeded to do business for the next 10 years until that company changed its name in 2017. But that goes back to my point that you want the names to either be the exact same. When we get to the similarity analysis, a lot more needs to come in. There needs to be a weighting of the evidence, the type of thing a court or a jury should decide. I also want to point out, as to the question of PCS, that was not the company name, and it's unclear to me if we're complaining about Professional Construction Solutions versus Professional Contractor Solutions, or if we're complaining about PCS. Those should be two separate analyses that are undertaken by this board. With regards to PCS, there are multiple companies registered as PCS other than my client, or Professional Construction Solutions, LLC. And you can see those other PCSs on page 16 of the materials, one of which was a DBA registered prior to Professional Construction Solutions, LLC, the other two which are more recent companies. Lastly, and I think this is important, we talked about, or in the email that was submitted to this board, there were two allegations of confusion. We explained the only one we're aware of, which was the incident in the parking lot that happened back in August of 19. And in the trademark world, that would not qualify as true confusion. What we'd be looking for as trademark attorneys, what we want to present for evidence, would be someone who actually thought they were getting services from somebody, and that was actually the other company. What we would call this is just a mere mistake. You know, that someone made a Scrivener's type error when making a phone call or looking up a number. And we put the logos on page 3 as well for the board to be able to see, and the logos are markedly different. To be clear, we don't ever advertise just the 3 letters PCS outside of the logo. My client came here today, he's wearing the PCS hat. All of our materials have that PCS logo on it. So it's not as though you're going to see just the letters without the design mark. You're always going to see the design mark associated with it. And then lastly, and this is important too, with regards to federal trademark registrations for PCS, Professional Construction Solutions, LLC, obtained a Tennessee trademark registration after all of this happened. And I mentioned that because at that time there was, as I have researched last night, 16 other PCSs already federally registered with the USPTO, and there are now currently 31 PCSs registered. And we attached those printouts on pages 18 and 19 of the materials. That's important because when you apply for a Tennessee state trademark registration, you have to aver under oath that there are no federal trademark registrations likely to be confused with your mark. And we don't know what happened in regards to that averment that was done by Professional Construction Solutions. Again, that's typically the type of thing that would be discussed during a lawsuit. And that's what I want to come back to at the end of this. This type of dispute over a trademark or trade name and allegations of purported infringement or unfair competition, likelihood of confusion, they're weighty disputes. There's a reason our legislature, the federal legislature, and the state legislature has set up trademark rights, that they should be decided based on the evidence, not based on one email without any attached evidence. We think that doing it this way creates a risky precedent going forward, and we would respectfully ask the board to reconsider its decision. And if there's any questions, I'd be happy to answer from any of the board members. I like talking about trademarks in case y'all can't tell.
Questions?
And I'm not sure if there's anybody from Professional Construction Solutions, LLC, if you want to speak. Okay.
Thank you.
Thank you.
Good morning, Board. I do thank you for the opportunity to speak before you. As mentioned, just a quick background. This board awarded my license in 2009. I've spent 11 years, blood, sweat, and tears, building a business. Twice this board has thankfully, due to my references and increased work, increased my limit, not once, but twice. I, as mentioned, found out about the other PCS. I was contacted in August by somebody looking to get my automobile insurance because my vehicle had been in an accident with their company. And so I immediately, I've only got 2 other vehicles, called my guys and said, have you been in a wreck? I said, no, sir, no, sir. So I reached back out to the gentleman, and sure enough, he sent a text with the PCS truck on the back, and they are correct. It is non-commercial tags. It's personal tags. And this person mentioned they were unable to get in touch by calling the 949 number 8099 in the text that they took. So they did a quick Google search, and guess what? My company comes up. When you search their name, as important as Google is in this company, my name came up. And so I immediately wanted to say, who is this? And so I got online and discovered that they were recently awarded a license. And so I reached out to the owners. Yeah, tried to attempt to reach out, peacefully, and kind of explain to let him know that who I was and how long I'd been in business and the type of work we did. And he was unwilling to make a name change. So it was at that point we did hire Richard Spohr with Bassberry and Sims, and in August mailed them a letter requesting that Professional Contractor Solutions cease the use of all name. They requested a few weeks to look it over. We granted those few weeks, but then never got a reply back. And it was at that point I decided to appeal to you, the board, because the reality is, you as a board, it's not your main objective to look after my business or their business. It's your objective to look after the citizens of Tennessee, to look after the citizens who are hiring contractors. And yes, it was mentioned that there are other PCSs. But what they failed to disclose was that at this point we just have 2 PCSs, me, Professional Construction Solutions, them being Professional Contractor Solutions, working in the Memphis market doing the exact same work. So with that is my appeal, is there's definitely, as we have seen, an instance of confusion, and that is not the only case. Brandon Smith, owner of Gutter Fabricators, a couple of months later called me up and was thanking me for hiring his friend. And I was like, what's your friend's name? He didn't know the friend's name. Called back. I couldn't verify that it was me. And I didn't hire him. They hired him. One of my employees at one of the supply houses went to make a purchase. And the purchase company wanted to determine why I moved to Bartlett. And I said, we haven't moved to Bartlett. We work in Collierville. Sure enough, they were trying to make a purchase of materials on their account. And it's those type of things, not only protecting my business, but your business as well, but ultimately looking after the residents of Tennessee. As mentioned, I do have the trademark. It was registered after this went down, but it is registered. The DBA, the PCS, the trademark, and that's the issue. Is people see that PCS, not only professional contractor, but they see that PCS, and they get us mixed up. And I wish him the best. I want him to make a lot of money. I want him to do a good job. I just want him to pick any other name other than this name. And as previously mentioned, this board has already requested that he make a name change, and I just request that you stick with that original decision. Any questions for me?
How do you feel about Professional Concrete Services?
I have no problems with Professional Concrete Services unless they were advertising like using that PCS logo. And I don't believe that company is in the Memphis market.
Chris, you've been in business since 2009 using...
2009, yes, sir.
And just to bring to the board's attention, and I included it into the letter that was sent out to the licensees, and I think Nick may have touched on it, but the board's responsibility is set forth in TCA 62.6.111 subpart M. which indicates that the board shall deny any application for licensure. As a contractor, if the board determines that the name under which the applicant will be trading is identical with the name being used by an existing licensee, or is so nearly similar to the name being used by an existing licensee that it is likely to cause confusion on the part of the public at large. And it indicates that this section does not apply to any applicant who's acquired an exclusive right of a registered trademark. Additionally, the application that was signed by both companies does indicate that they checked our system to make sure that that name was not being used, and I just wanted to bring that forth for the board's consideration as well.
If we had a company apply for a license in the state of Tennessee with Professional Contractors Solutions of Washington County, would we have to respectfully deny that license?
If the board feels that that is so similar that it would cause confusion for the public, I think the statute is saying that you should deny that application. But I think that's why I think it's a case by case, because you need to decide if it's so similar that it could cause confusion for the public at large.
How many miles apart are your two businesses?
We operate in multiple cities. As far as the head professional Bartlett, Professional Construction Solutions,
Collierville,
And
20 miles.
20 miles?
20 miles. And I work in the Memphis market, and yes, they do some work, but if you went on their social media page, 90% of their work overlaps where we work. Shelby County, Fayette County, Tipton County.
In that case, my client, Mr. Barkley, is here with me today, and he would like to say something briefly if the board would allow.
And as far as the market that we work in, this gentleman, what he advertises on his website is he does commercial build-outs for doctors' offices and dentists, and then also, I guess, used to be a home builder. We do none of those things. What we do is mainly renovations, restoration work with insurance claims as far as like wind, hail, fire, water, things like that. So as far as us being in the same market, I've been a contractor. I just got this company name because I split with a longtime partner. I've been a general contractor in Memphis since 2013. I've never run into him. I've never heard of his company before. And like I said, that we do two completely different avenues. I mean, construction, saying that we're in the same market, that's way too vague. There's specific markets that you're in construction, which he's in specifically, per his website, he does build-outs of commercial doctors and dentist office. I've never done that. I have no need to, no want, anything like that, as well as building homes. So, and we're, like he said, my lawyer said, we are in the Memphis market, Jackson, Nashville, Huntsville, Alabama, as well too. So we're not just in that market, but I've never had any instance of ever hearing his name before we had this instance pop up as well too. So as far as confusion, as well, the PCS, obviously our logos are completely different. I don't see how somebody could see my PCS and think that it is his PCS. So that's pretty much.
It looks like that. Did you have Nailed It Construction Services at one time?
Well, so that's the split from the partnership. It used to be D&D Renovations.
And then D&D Renovations?
Yes, sir.
D&D General Contracting?
Yeah, yes, sir.
BZ Construction?
Yep.
D&D Renovations again. H&H Restoration? H&H Restoration?
Yeah, so those were all actually the same company. Those were just name changes.
Why did you get rid of all these and come up with something new?
H&H Restoration, I started that company by myself. In 2015, I took on a partner, David Zinn. That's when we switched it to D&D. His name was David as well, hence the D&D. We had our home improvement contractor's license. He went and took That was formed under H&H and then brought over to the D&D name. And then he went and took the test for our general contractor's license. Just to obtain that license, we started BZ Construction. I'm not sure exactly the exact reasoning for it, but I think it was time. We had a big project that we wanted to do that we had to have that general contractor's license for. So we just did that name and then switched it over to D&D General Contracting, and then we were informed that we could house it all under the D&D name. So I can definitely see where that looks a little screwy, but it was just because of timing, and then also, like I said, partnership, people coming in. And then when I split with my partner, because he was the qualifying agent, he switched the name from D&D to Nailed It Construction. That's what it is right now.
Sorry, just one point to what Ms. Thomas said about the TCA statute, because I think this is important. The statute concerns the name. It doesn't relate to the trademark. The names were Professional Contractor Solutions, Inc., my client, Professional Construction Solutions, LLC, the party that made the claim. The party then later on, after all this has occurred, does the DBA. So when we're talking about were these two names too similar, looking at PCS now after the fact, when he had already set up his company, to me that's a separate issue. We're talking about these two business names, Professional Construction Solutions, LLC, Professional Contractor Solutions, Inc. And Mr. Whittington, you asked a question about professional concrete services. I think there is also a Professional Concrete Solutions that's been registered, as well as the multiple PCSs we've seen. To your question about the board and the registration of names like PCS of Atoka, I believe Mr. Tickles from Millington, PCS of Millington, he may know Mr. Harper from Atoka previously. When they go to register that name, the Secretary of State, if it's not the same name, they're going to register it. So what I mean, if it's not PCS LLC, they're going to go ahead and put it up there. They're not doing any type of analysis. And I'm not sure, based on the records, what analysis is being done. What I want to be careful with the board and the precedent it sets is try just to avoid being arbitrary about this. I know that's an important word when it comes to the Administrative Act. We want these things to be based on evidence and not a arbitrary decision that's made without some type of support, given the large financial impact it'll have on my client, the amount of money he's put into this, advertising, building up this business. Last point is Mr. Harper from Professional Construction Solutions, LLC, made the mention that he sent the email after we received the letter from Bass Berry. The timeline was reversed. The email came out the 12th. We received the letter from Bass Berry the 22nd. I had a conversation with Mr. Spohr. I did ask for more time to respond, but also told Mr. Spohr it's a generic name. It's generic, at best descriptive. You're not going to be able to demonstrate any trademark rights in this. And we never heard from him again. And I'll venture why, gentlemen, is because Bass Berry attorneys, they're very savvy. I've done trademark cases with them. They probably said, you don't want to have this fight, okay? This is not the type of trademark you want to go to the mattresses on. Thank you.
Question for you.
Yes, sir, Mr. Whittington.
If the board decides to abide or stand by its previous decision, are you all going to take this into further litigation?
That's a conversation I'd have to have, Mr. Whittington, with my client at this point.
Well, I've got a feeling by listening to both sides here this morning, no matter what we decide, this is going to be taken to another level. And what I'm getting at, just for board members, my train of thought is maybe this is a matter that's better resolved between the parties, either through litigation or through agreement. I don't know what else the board can do, is my thoughts. We've issued what we felt like, after considerable deliberation, what we thought was the right thing to do, and there's a disagreement, and I don't see that we're going to be able to help either one of you any further.
A couple of points to that, Mr. Whittington. If I first understand the question, if the board upholds its decision, would we consider appealing that under the Administrative Act? Possibly. If the board reverses its decision and does not force my client to change its name, then yes, I do think that that is something that should be done, and the dispute should be had through to private companies. Like most trademark names, disputes are resolved. As to the first question, would we pursue something under the Administrative Act? I'd have to speak with my client to get make a decision on that. I would ask, and at the very end of my materials on page 4, I do make the request, and I would reiterate it here, if the board is going to uphold its decision, we get a longer timeline to make any changes, given the money that goes into making these changes. I'll give the board a quick example that I think they'll find humorous. I got a letter from the University of Texas last week in regards to a high school in Johnson County, Tennessee, requesting that they change the mascot, the Longhorns, that the high school has used since 1933 because our friends down in the University of Texas at Austin claim trademark rights for the Longhorns. In that letter, they proposed 3 years to allow us to make the change. I'm not asking for that long, but I give you that example to say because of the amount of time and effort and money it takes to make these changes, to the extent the board is inclined to uphold its decision, and again, we would ask that it reconsider it, but if it is, we'd ask for a considerable amount of time to make the change. Thank you.
I'm looking at the license factor. Professional Construction Solutions, LLC. The original license was in 1/21/2009. Professional Contractor Solution, INC, is 8/2/2009, which is less than a year. It correct?
2019.
2000. Mine's
11 years later.
Yeah.
We're only,
Yeah. That's what I'm saying, 11 years difference between the two. from
Correct,
when
Mr. Tickle. Yes.
So I'm just trying to
And
see who came first. And coming first, it looked like the LLC came before the INC.
It-
And making it easier.
I don't think we can dispute that.
For the license point. And just kind of looking at it on the broad side. And I understand where you're coming from on trying to give you a time frame as to if y'all decide, if whatever's decided, if you need more time. I understand where you're coming from on that,
Thank you,
too.
Mr. Tickle.
And I wish I knew both gentlemen. I should, but I don't. And I'd love to meet y'all later. And so anyway, thank you.
I can
Because
ask you a
y'all
quick
right there,
question.
hometown.
Just because we're trying to make it clear for the public to not cause that confusion, how does your client, I guess, market or advertise? They advertise as PCS or professional? And I'm just trying to get the information out for the board.
We use the logo. I mean, that logo, you can see it on materials he was pointing to that I brought some, and Ms. Thomas, you can see him. You can show him to the board if you'd like. Mr. Tickle, if I could just make one response to your question about the timing, that goes back to my very first point that the tenor and underlying reason of his email isn't about the name. It's about PCS. And so when we look at the timing, I think the timing of deciding those two names is something totally different from the PCS dispute. And that's what really Mr. Harper was here today and in the email complaining about. He wasn't PCS with this board, licensed, approved by this board when we registered our name. He has now done a DBA for PCS at a later time after the fact and after this board has approved other PCS licenses for other companies out there. To be clear, to the extent we did change the name, and I think I'm right on this, the trademark issues are unrelated to this board. Anyone can do it. They have a company name, Nick Vescovo Inc., but then I can do a DBA as Bishop's Builders. I don't think, if I understand it correctly, this board would approve the trademark marketing. They would just be able to have to use that company name on the materials, if that was clear as mud.
About like mud, but okay.
Yeah.
Sounds good.
Thank you, Mr. Tickle.
I understood what you were saying. Like I said, I was asking the question to kind of put out there as part of the discussion, the part about public confusion, and that's why I asked that question.
Thank you, Ms. Thomas. And again, we're not aware of any instances of public confusion. What we have is a woman trying to locate us after a car wreck, and then what we just heard for the first time today was a gentleman referring the that we did good work. So I'm not sure if that's the type of confusion you want to be scared about. But when we advertise, yes, we use the logo, and I've looked at Professional Construction Solutions LLC's logo. They're completely different. I'm not sure of any advertising. I've never seen any. I haven't been able to locate any other than the website. Yes, thank you.
Thank you. They are correct. I don't do a lot of advertising. All of my work is done word of mouth on referral from previous clients to next clients. To clarify, I am not only the PCS, but the Professional Contractor Solutions. And the biggest, I think I want to point out is he did mention that at this point, his biggest market is renovation, restoration work. However, his state of Tennessee license is a residential small commercial contractor. My license is a residential small commercial contractor. So from this point, he is licensed by the state to do exactly what I do. And once again, I think your job as a board is not to decide the dispute between these two companies, but to determine is there a potential risk to the citizens of Tennessee that could confuse our two companies. And yes, I do have a concern, Mr. Tickle, about the multiple number of name changes over the few years. And I've spent 11 years, like you said, trying to build a company based on reputation. So I thank you for your time.
Reese, you got any input or comments?
No, I personally don't see any reason why we should change what we did at a previous meeting. He hadn't had any trouble changing his name over several years, but
I would have to agree with that. I don't see what the problem. I mean, they're 5 months. Contractor Solutions are 5 months into basically a new business. Why look forward to the rest of your life and running into these issues? Just fix it early and go on.
Mark, you got anything?
The reason that I would say is because even though it's only been about 5 months, I have dropped a considerable amount of money, upwards of $30,000 between hats, shirts, marketing material, wraps on my vehicles, wraps on my trailers, all these sorts of things. So that to me is the biggest financial burden that I'm going to take on because of this decision. So that's one of the main reasons. And because of the name changes, those, the name change that happened here recently was because of a split in partnership. So it wasn't just an arbitrary decision to change the name. So thank you.
I'm going to make a motion the board stand by its previous decision.
Second.
All right, we have a motion and a second. All those in favor?
Aye.
Any opposed? Thank you.
We just wanted to know about the time frame, if there was any extension on that. It was previously.
Right, because the initial letter did say to start taking the steps, begin the process of changing the name within 30 days of receipt of that letter. So if the board wants to extend the time frame to begin that proceeding, I guess now will be the best time to let them know that.
And also, if we could just get clarity too on the PCS, if the board is saying we can't use the letter abbreviation PCS, because the name is separate from PCS.
PCS is the logo. Is that what you're?
Correct, Mr. Tickle.
Is that what we're dealing with right this minute?
Yes, sir.
You want to keep the PCS logo how y'all have it described?
We'd like to. I'm not sure the board can make a ruling that we can't use the logo. That's what I'm trying to figure out.
I don't know. I'm just asking. I'm just trying to clarify my brain.
be the name of your company.
Well, the company could be Professional Consulting Services, LLC. And then we can still maintain the PCS.
And I would agree with Nick. I think that the issue is the actual license name, not necessarily the logo. Those are two different issues.
Respectfully, I'm not sure the board can order us to change the logo, and I say that with the utmost respect.
No, I think, you may be right, but we ruled on the names on the
Names,
license,
yeah.
right? And that's all we've been asked to do.
Right.
That's all that's in in the statute. So I think that's all
Correct.
that's all we've done by making the ruling that we did.
Thank you, Mr. Chase.
Yeah.
In regards to the timing, I think maybe 180 days from today.
I'm in agreement. Can I
Or
second that?
February 1st, if you want to keep it.
I like that, Mr. Smith. Thank you. That makes it easier for me calendaring it.
Yeah.
Thank you.
We have a motion for 180 days starting February the 1st.
And I'll second it.
We have a motion and a second. All those in favor?
Aye.
Any opposed? All right.
Thank you, gentlemen.
Thank you, guys. All right. Carolyn, any updates? I know we have an update on legislation. Make sure everybody shows up half the time.
Yes, that's the only legislative update, was the Senate Bill 1691 that extends the board through 2026, June 30th of 2026, and just changes the attendance requirement that anybody that misses more than half the meetings, Carolyn is required to report you all to the governor.
All right. I think we can deal with that. Formal hearings, we have a formal hearing. Is it starting at 1? Do we have time to go eat something, you think?
I told the judge that it may not start right at 1 because there was the board meeting beforehand. So,
Okay.
Could start a little early.
well, if you all.
No,
We can do that, yeah.
the judge won't crank it up.
But I did let him know as well as the respondent.
Going to skip down to new business. That'll eliminate some stuff. Then come back. Do we have time?
Yeah. But we need to look at the budget too, or not?
Pretty much it's
Just
right
what's
on
in
track.
Okay. Is there any new business?
No new business.
Let me ask you on the new, I don't know if it is or not, but this Tennessee Commerce Insurance that we're doing on trying to get education and all that,
Yes.
what really ruling do we have right now?
We'll have the rulemaking hearing at the March meeting. So we have the draft rules that you all have already approved, and then they should go in effect after the rulemaking hearing.
Right. And we had to push it because statute requires that we give the public 45 days notice before we actually hold the hearing, and the approval process pushed that back, and so we had to push the actual hearing back to the March meeting.
So on our March meeting, we're going to decide exactly what everybody's going to do. Is that correct?
So I thought we had approval on the language, and so what would happen is we're going to present that language to the public, and they can provide comments, and you can make changes as you see fit based on those comments, if that's what the board decides.
Well, I'll say the Memphis group, Home Builders Association, they don't really understand what's going on this last. When I renew my contract selection, what will I have to submit to show that I completed the 8 hours continued education? See, the state doesn't really understand that. Our other associations don't understand that, and they really would like some more clarification than what we have here. And I told them I'd know something when I go back to Memphis, but I really don't know anything. I think that's what you're telling me.
I can give you, I can type in the site.
I would appreciate that because I'm tired of getting drilled. All right, thanks.
On the attendance resolution, are there excused absences?
I'm sure they would look at that.
I'm sure if she had to report it, they would look at why you missed the meetings, but the language of the statute just says anybody that misses more than half, she has to provide their name to the governor's office, and then they probably would investigate from there.
I think the intent was to get the chronic absenteeism
Absolutely.
stopped, but also that would have been nice if it would have made an allowance, you know.
And I've
None
seen
of
this
us are
language.
spring chickens, and we may have to have different things that keep us from attending, so.
And I've seen this language attached to other boards as well, so it wasn't an attack. It was
Not picking on us.
They're not picking on you. They've added that language to
Wasn't
many
it
of
already in there 2/3 or something?
2/3 was the original language. They're changing it to more than half.
Anything else? All right, the meeting is adjourned.
They can do something about that.
Right?
Now, I gotta figure out.
Realistically, you only
Better deal for
get one more.
money.